Today we're going to be covering essentially, the impacts of 2024. I think that there was a part of me hoping for much better news, obviously not only at the federal level, but locally as well. So we have a little bit less to report and kind of than we were hoping. So for folks who may be less familiar with Movement Legal, we are the California Center for Movement Legal Services. We spun out of ACE, which is a statewide community-based organizing group. The focus of our work is we craft legislation at the behest of the community and its organizing. We bring impact cases, and we also do work that essentially is defending the tenant movement. And sometimes that's making sure we don't overturn some of our wins. So today what I wanted to cover are wins and losses from 2024, and then some new ordinances that people may be less familiar with that have passed over the last few months. And then we'll have some discussion on what to do in areas where there have been losses, and maybe just talk generally about what does it mean, some of the ramifications. We saw a lot of super progressive tenant advocates not win that I can talk about, and we'll maybe have some conversation about that. All right, so frankly, the wins are not that many, but there were three bits of good news. One is that Measure BB in Berkeley, which was about strengthening and updating the rent control ordinance, passed. Santa Ana had put the rent stabilization and just cause that had been passed by the council. They put it on the ballot in a way to codify and protect it so it couldn't just be easily redone, as they kept trying to get council members off of their council. And then Measure CC, which was also in Berkeley, this was called the corporate con. It failed, and this would have been the first time, at least in Berkeley, that they would have reduced a sitting ordinance. And that failed miserably, although over $300,000 was spent. So losses, at the state level, 33 and 5 both did not pass. They did pass in a lot of the areas that, are stronger rent control areas. Prop 33, just to remind folks, was the ballot measure that would have repealed Costa Hawkins, allowing us to basically extend the date or limit what we consider new construction. Right now, you can't pass rent control on properties that were built after 1995. And then, of course, in areas that have older, maybe we can call them legacy ordinances, their new construction definitions are a moment in time, what their definitions were at the time that Costa Hawkins was passed. So you have situations where Richmond, a newer ordinance, their units are covered through 1995, but Berkeley is, the cutoff date is 1979. So, and then Proposition 5 was the ballot measure that would have allowed tenants, would have been a bond that we could, it's not a bond, it's to lower the percentage that you need when you're trying to pass bonds, with the hope of being able to make it easier to pass housing bonds. So the other kind of devastating thing, and I think one of the biggest concerns, is that all of the rent control measures lost. And that included the repeal in Fairfax. So we'll talk more about kind of what that means, particularly in situations where you lose rent control later in the presentation. So we did have new ordinances that passed, as we were saying. The Berkeley measure passed. One of the biggest changes that measure did that I want folks to know about is just the right to organize. And this was a you know, based on similar law that San Francisco has passed. And this is basically really codifying and providing much more structure to the right to organize. So when a building wants to create an official building union, they need 51% of the tenants to vote yes, and then they get different rights. And one additional one is that landlords are required to meet with the tenants at least 3 times a year. And if the landlord fails to meet or to meet and confer in good faith, that is considered a housing service and means that they can then ask for a reduction in rent through the rent board hearing officer. And you know, we've seen that in San Francisco that has really buttressed the organizing, and it has really facilitated requiring corporate landlords to negotiate with tenants. And even, you know, Berkeley has seen a huge growth in the percentage of housing that is owned by corporations. That's another thing, is that just in terms of getting into the weeds a little bit on this right to organize, is that it's 10 units or more owned by a corporation, or any unit that is managed, so by a management company. So the idea is that it's not so much about small landlord or big landlord, it's about whether the landlord, if you own 2 units, but you basically delegate the management to a management company, then the tenants can organize. And so it's this idea that if they can't interact directly with the owner one-on-one, then they should have the right to organize. So it'll be interesting to see, you know, because that is an addition that isn't in the San Francisco version, but that management component. The other thing is it includes all tax credit properties. So it doesn't matter even if it's owned by a nonprofit, they're all included. And it also includes all properties that are owned by the government, by a government agency, if it is not the Berkeley Housing Authority or the County Housing Authority. So you have to be the Alameda or Berkeley, otherwise it is covered. The other big change in Berkeley, which was not part of the ballot measure, is the upzoning protections. And Berkeley has done this, and Los Angeles has been doing this work as well. Really want to raise this, and a lot of what kind of, as I'm going through these, you know, I think it's hopefully helpful for folks who practice in these areas, but it's also, I think, an opportunity to see the themes and some of the pieces that are growing. And, you know, as we're always closing loopholes, these are some of the pieces that I think are going to be important. I also wanted just to pause a second to see if there were any questions about what I've covered so far. All right, well, it sounds like there aren't any, so I will continue on. So the other piece in terms of Berkeley's is just that we lowered the 5% rent cap. It's always been 60% of CPI. The rent cap used to be 7%, but we've now switched it. Going back to the upzoning issue, so I think many folks are struggling with there's now this attempt, whether it's building ADUs or you know, tearing down 4-unit buildings to build 12-unit buildings, or 10-unit buildings to build 70 units, which is what is happening in a lot of areas. And what happens is that, you know, it really targets rent-controlled properties, single-family homes in more working-class neighborhoods. And so what this does is it requires that all rent-controlled units have to be that where the landlord wants to demolish to build new housing, they have to replace it 1-for-1, which is part of state law, but this goes a step further because it's not just about, it basically keeps the rent control and keeps it under the rent board, but it also provides the BMR protections as well as the rent control protection. So and from Berkeley's perspective, it was a way to really have the best of both worlds. And if folks want to have more, you know, they're hopefully in the discussion piece, if this is something you feel like is going to be really important in your community. So now I'm going to move on to Los Angeles. So in terms of over the last year, there have just been, a lot of work to close in on, really strengthening the local protections. There's also been a lot of work at the county level, which actually I didn't touch upon as much here. This is mostly the city of Los Angeles, but we can, add in. And so one of the big successes recently is to close some big loopholes in their tenant harassment ordinance. One was to really focus in on, what the definition of harassment is, and that it's a willful, reckless, and grossly negligent conduct. Then the other thing was to really strengthen attorney's fees, making them mandatory for folks who've been following this or maybe following, Tahoe ordinances. One of the big issues is that if essentially, to enforce these, it has to be not only worth it for the attorneys who are willing to do it, but also it's more than just like, the cost of doing business for landlords. So really putting some teeth into it. And so they did that, mandatory attorney's fees, and then only for the prevailing tenant. Also triple damages, as well as minimum statutory penalties of $2,000 per violation. It also prohibits the unilateral lease changes. Some cities, some other cities have either done that directly, that you can't be evicted for unilateral lease changes. This makes it a violation and recognizes it as a form of harassment. Just any kind of lease change, and so you no longer be able to do that. I know that has been in many areas, an important kind of loophole to close. So they've done it inside of their anti-harassment ordinance, and it's already existed in the just cause ordinance for a long time. And then we've got protections against landlord abuse. This is the more traditional structure within these anti-harassment ordinances. And this is about the right of entry into the unit and things that you can and cannot do. So entering or photographing portions of a unit beyond the scope of the notice, failing to state the specific reason. Obviously, I think many of us have been asking for that. Failing to reasonably coordinate with the tenant's schedule, making an announcement barely 24 hours before when you know that the person works during the day, or on a school holiday when obviously all of their children will be home. Misrepresenting the reason for entry, and failing to provide a reasonable time window. We've seen notices where people say, we will be entering over the next 30 days. Failing to tell a tenant that the requested entry was canceled. So somebody, stays home from work and nobody shows up, and excessively requesting entry not justified by the reason. Another addition is failure to accept or facilitate rental assistance payments is considered harassment. And I think that one of the things that is just, really important is all these great, as we've been seeing these policies, evolving, seeing the growth and where we're all learning from each other in different jurisdictions. Another big issue, and this is not new to those of us who've been doing this work, we saw that as soon as the tenant protection ordinance at the state level was passed, it left open that you could evict people if you were doing substantial remodel. What we call this the renovictions. So although Los Angeles had actually gotten rid of renovictions in the 90s and had a 4-year moratorium of them, bizarrely, when they went to extend the just cause ordinance, so it used to be that in Los Angeles, you only had just cause if you had rent control, and then council extended it. One of the things they did is they adopted basically a substantial remodel from the state law instead of using the rest of just cause. So immediately, we saw buildings where landlords went in and said that, tried to evict everybody in the building. And so that is now just, is just about to be, that ordinance is happening and closing that loophole. So it's in process. So City Council has voted for the city attorney to draft an urgency ordinance, so they'll be passing another moratorium. Which is ironic since this is why it's so important for us to all be students of history, is so that we don't have to repeat these issues. So I know that lots of folks are still struggling if they don't have local ordinances with the substantial remodel. But just for folks to know that now Los Angeles is closing it for their post-95 just cause. And then the resident protection ordinance, which is similar to what I was describing that Berkeley had done. This is addressing upzoning and, trying to find a balance between the need for new units and it not coming on the back of destroying not only rent-controlled units, but also on the backs of the folks who live in them, so that as we are increasing our housing stock and improving our housing stock, that it's really the tenants who live in those communities who benefit and that they can come back. So in Los Angeles, this focuses new protections for tenants displaced by demolition. It also alters replacement unit requirements in certain cases, and it adds significantly higher relocation requirements during and notification periods for tenants. I think that, and it also has a right of action when the landlord isn't following the process. But I think what's key here is, as we do this upzoning, ensuring that we're paying attention to what happens to tenants while they're rebuilding, and that so that tenants can come back. So just kind of zooming through this, it has been, since 2015, obviously we've been passing lots of ordinances across the state. I think this year is the year where people were doing them at the local level, which is really, really great. And in kind of this newer, in the suburbs, the had not been historically traditional for tenant protection. So Concord, a perfect example of that. This was an 8-year fight. And I'm sorry, as I'm going through this, I haven't been kind of acknowledging all the different organizations that have been participating in these. If I'm realizing that's anyway, so obviously lots of community support. Organizing has been so important. Raise the Roof, I think, is one of the main coalitions that was able to bring this forward. And so anyway, getting to Concord, another example of a strong ordinance. There are some things that are a little bit unusual, but that often happens when you're doing it at the council level and you compromises. So in terms of just cause, it has, as we were saying, a right to return at the same rent following renovations, this substantial rehabilitation, and some of the ordinances use different wording. It has full implementation of the LAAC. This is great. It has the school year protections for owner move-ins and renovation. So you can't say you need to move out for 6 months during the school year, and that's a little bit a newer piece, is to include that in the renovation temporary eviction. It has, and I think you'll see that most of the local ordinances actually have very kind of lower amount of relocation as compared to some of the more legacy ordinances. And I think it may be because, the housing crisis is so much worse in the urban area, the bigger cities, the legacy rent control ordinances. But it also, it also kind of reflects what has been successful from the apartment association in terms of their negotiation. But I would say that the most compelling and seems to be strategically successful model in terms of how you decide the relocation has been based on using the HUD fair markets and it being a multiple of how many months. So it'll be interesting as folks are exploring in their own communities, that does seem to be the trend in how folks are handling relocation. When it comes to rent control, again, 60% of CPI with that 3% cap, whichever, actually this should be whichever is lower. And that one thing that they put in Concord is to do where the council is going to do a yearly review, which obviously is, you know, one of those compromises that had to be made. I have been hearing more and more that cities are saying Concord, because of the city's reputation as not being, you know, a big, you know, doesn't have a reputation of being, you know, radical, but just note that that has that. So when if you're in a jurisdiction that's saying, oh, let's look at Concord, note that they do have a yearly review. There's remedies for a violation, including a petition process, which has just started. It did have a city that has been very willing to set up the procedures, and it's going to have a full kind of rent program. Another thing to note in terms of you know, is it the perfect ordinance? Right to 1 year lease. Now, this is a concept, I think, I mean, I'm familiar with it coming out of Glendale. It is something that happens in other cities outside of California, is this idea you have to keep offering another year lease. I think that the problem is that isn't necessary when you have a just cause ordinance. And in many situations, tenants don't want to be forced into signing on to another lease. And we see that a lot in the newer construction, where tenants have to choose between a higher rent increase or entering into another lease. And then it's harder for tenants to get out of the lease. This is, you know, in some ways could be interpreted that a landlord really can't terminate a tenancy because they have to constantly offer another year lease. So I would just, again, be careful with that. We're kind of monitoring to see how that plays out, because our concern is if it gets interpreted that it's basically saying you can't evict, you can't use any of the no fault evictions because you always can just ask for another lease. So we should all just kind of keep watching how that plays out, because usually you have either a right to a 1 year lease or you have just cause. You usually don't have those two policies together. And also just to note that the landlords did try and do a referendum, which failed big time. You know, and so it makes you think that, you know, referendums are just not possible when a city is over a certain size, unless massive amounts of money come in. And for whatever reason, the apartment association did not participate in the referendum, and it was actually much more of a real local realtor action, and they weren't successful. Antioch also had actually passed rent control last year, kind of one of the new things we've been seeing, where people are passing rent control first and then just cause for eviction. That again has the same 60% of CPI or 3%. Again, it's not whichever is greater, it should be whichever is lower. Strong remedies for violations, again, the petition process. While Antioch really has all of the structures in their ordinance, their city really hasn't set up any of the infrastructure yet. And their anti-harassment is a model we really think is one of the strongest in the state. It's really a model. They really took it, you know, Movement Legal worked with them really closely, and they used it just like Richmond's, very similar to that, very similar to Oakland's, really strong one. So if you're looking for anti-harassment ordinances, Antioch is another great model. In terms of just cause, you know, I think just highlights right to return at the same rent, following repairs, full LAAC implementation. Again, that relocation being much lower compared to what I'm going to call the legacy rent control jurisdictions. There's just a lot of little quirks with the just cause. There's a lot of compromise, but still, I think, you know, those important, the LAAC implementation, you know, super strong, as well as ensuring that people aren't evicted for major repairs. Another thing we'd like to highlight is that in, Sonoma County recently passed a just cause expansion. And, I think expansion in that it's, includes that it's more so than essentially comparing it to state law. And what we're looking at is that, people are covered as of day one. It includes deed restricted housing or tax credits, you could say. Another important trend is that those more and more are being covered. And it has increased relocation payments than obviously the state law. All the units must be registered. That was really interesting in terms of wanting there to be a registration. And then also, I think another theme in terms of as we're making ordinances stronger, it's creating equal to monthly fair market rent. So this is something we saw in Los Angeles, I think, was developed in Los Angeles, was included in Oakland's. It's in Measure BB in Berkeley and in Sonoma County, which is that and Concord also has this, where you cannot, if you're being evicted, you cannot be evicted until you owe the equal of a fair market rent for the rental unit. The other really, so here it's 1 month's rent for the rental unit. It's not the HUD amount, which is what the HUD's fair market. So here it's the actual rent. And for Sonoma's, we've got some of the language, you can look at it. But what is particularly unique for Sonoma's is that there is an automatic moratorium triggered for just cause protections when there's a disaster. And why that's important is that, we have a situation, it obviously is an area that has had severe floods and fires. And so, having just this automatic thing having to happen, and it means that it also expands. It says you can't have any no fault, just like no eviction, similar to the robust eviction moratoriums that existed during the pandemic. And so, I think that it's, it's something for all of us to consider. Now, just to remind everybody, you don't have to have any kind of crisis to have a moratorium. I mean, to have just cause for eviction or for rent control, right? You can have a need. It just has to be a public, valid use of the police powers, and an emergency is not required. However, to have a moratorium where you have no evictions, to have this like higher level, is really important, especially as climate change is really leading to so many disasters, for that to happen right away instead of all of us having to spend our energy focusing on that. So I think that'll be a really helpful thing for folks to look at, as ways to strengthen the protection. So this is a really good model for that. And we just have the language since we're going to be sharing this out with folks. All right. So another one I hope folks are aware, Salinas, California passed an ordinance. The rent increase is 2.75% or 75% of the consumer price index, whichever is lower. It also has buyout protections, which, I think all of these new ones have. It also has just cause eviction, a lot of the kind of the typical tenants, and it also has a strong tenant harassment ordinance similar to Oakland and the new one in Los Angeles. That one is not going into effect until January 1st, 2025. And so I just really want to note that, because I think historically we have been doing rollbacks and having things go into effect right away to protect. So that's something to, a trend, maybe not in the ideal direction. And so just, again, I'm pointing this out so that when people say, oh, Salinas, that's in our jurisdiction, let's look at that one. Pay attention to when it goes into effect, because what you don't want is having landlords raising the rent. So that's why we have these rollbacks. Another thing I just wanted to mention, San Francisco outlawed price fixing schemes designed by Real Pages. This is You know, so another ordinance that folks may want to consider in their local communities. All right, so before we move on to the what to do now, I want us to kind of come out for a minute and see if there are any questions. Did we have any questions, or should I just keep going? All right, I'm not seeing any questions in here. All right. So I think now, you know, I think the discussion is, you know, what do we do in these situations with the, you know, the areas where we lost these protections. So, you know, Proposition 33 was really important, but in some ways it was status quo. And I would say in general, we were in a status quo situation across the state. A lot of incumbents won, but we did see a lot of loss, like on the election level. We saw a very progressive city council member lose in Richmond. We saw Dean Preston, I believe, is losing in San Francisco. So, you know, it's a bit of a blow for the tenant movement, and it's unclear, you know, is it that just so much money was spent, you know, by the National Association of Realtors, just seem to have dumped so much money all over. I think that's something that at some point when, you know, I feel like there's a lot of attention being spent on why the Democrats didn't win, you know, the presidency. But I think what we're missing is, you know, there was a big, you know, move to the right across the country. So I think the question is, you know, I think that happened in California too. I think a lot of progressives lost their seats. A lot of progressives didn't win against corporate candidates, people funded by corporations, regardless of what they actually said they stood for. So I think that's something we need to think about in terms of as we move forward. From a legal perspective, you know, I think that you know, I'm particularly concerned about tenants who lived in Marin. Those who are living in Fairfax and San Anselmo had protections. Larkspur has an older ordinance that has pretty high, not that much different than the state law. So I think it's you know, we're going to have to think about, you know, this is the first time where so many ballot measures lost for rent control. Historically, they had all passed. Usually, if you could get the signatures, you could pass. So it is going to be a time of reflection. I just want to remind folks, though, like in terms of when ordinances pass and how that interacts with when they're tenant ordinances, that, you know, there are two components that we always put into the ordinances so that they protect tenants as much as possible. Usually we're looking forward, right? We're saying if a tenant is being evicted and is in any stage of the eviction process, then they benefit from the protections. And then on the rent control side, we have these rollback dates. So it says your rent, your base rent is whatever it was on a certain date. So even if the landlords have increased it, then the rent goes back. So what happens in the opposite situation, right? Where you pass an ordinance and then it gets undone. Well, I think we argue that at the time the notice was served, that was the law. And so because there is now nothing, they have to follow the law as it was when the notice was written, because there is no retroactivity when you have, you know, when you basically, a law is, you know, when you basically erase the law, you know, so I think that I'm hoping that those are going to be arguments that will be successful in protecting folks. We know that there were folks who had gotten increased notices in Fairfax that were not lawful, but the question is now, what are those rent increases? And so it'll be interesting to see if landlords, you know, are really aggressive in those communities that lost their battles to pass those ordinances. But I do think that there is a little bit of a status quo, you know, that basically incumbents and more conservative folks seem to have won, and that may have really hurt us in terms of the amount of money spent on in a more conservative leaning. So I maybe went a little bit faster than I had meant to as we went through the training, but I've covered my material, and it doesn't seem like there are still any questions. Yaslin, do you want to give us a little guidance on what we should do now?
Yeah, we could give it a few minutes to see if anyone has any lingering questions in their mind, and then we'll go from there.
Great. And it would also be great to hear from folks if any of you do practice in the areas. If there's anyone here from Santa Ana, if there's anyone from any of these new ordinances, or particularly if there's anybody there from the North Bay, it'd be great to just hear if folks have more information to share with others, or if there's anybody working on ordinances, and if there's any particular you know, legislation that you're contemplating and how these pieces might you know, have an impact. Well, one of the little challenges we have here is that this is supposed to be an MCLE training, and so we don't want people to not get your full hour. And so we have two options. One is people can start asking questions, or we can go ahead and I can kind of go back to some of the policies that we can talk about with a little bit more detail. One of the things I do want to maybe discuss is the question of what are we going to do, like how, so somebody was asking, was there any information regarding San Bernardino or Riverside counties? There is not, there, as far as I know, there were no ordinances that were passed in San Bernardino or Riverside County. There hasn't been anything on the ballot. I do believe that Pomona does have rent control. But I think that's it. But if Judith, if you have more stuff you want to add, that would be great. And then what I was just going to elaborate on is the fact that just to kind of, you know, thinking from a housing perspective, what is it going to mean to have not only Republicans in office, but a Trump administration? I mean, I think that some of the things that I know our office has been discussing internally is the tax credit program. I know that we have been trying in California to really kind of protect tenants from, you know, this increasing number of, you know, out-of-state corporations coming in and buying up tax credits, or buying just even rent control properties and making them into tax credits. So I think that, you know, part of what we want to do is really, you know, thinking about like, that's something we want to address at the state level. You know, and I think the other issue is being cautious about what we're, you know, trying to keep things away from the Supreme Court, which I think many of us have been trying to do already. So unless there's any specific questions, or, you know, I know Katie, you had mentioned going into a little bit more detail. If there's anything, one particular ordinance or another, you'd want to do that, you know, we can do that. And if not, we may just wrap up and everyone can have 20 more minutes. You know, back, I know all of us are super, super busy, but we'll, so I do see a question. Can you share more about what makes Oakland, LA, and Selena's anti-harassment model? Is enforcement tenant triggered, or are tenants dependent on agencies? So, great question. Going back to, so just in general, so folks know, I mean, the way, you know, we've started calling them anti-harassment ordinances, but just, you know, the genesis of these ordinances were actually, they were called tenant protection ordinances. And the idea was, it was sort of like these consumer rights protections, because we had, you know, things that landlords were doing, you know, that didn't get captured in the rent control piece, didn't get captured in just cause. It was, I mean, and some of it was like living in a hostile home environment, right? It was things that they were doing to harass, and things that a lot of us really struggled to address. And it became a bigger and bigger issue for tenants who are living long-term, particularly in rent-controlled units. So they're all kind of like, if landlords do this, you know, they're all set up as like a list of bad behavior. What I'd say is, what's the difference between a good ordinance and a not very good ordinance? Yes, to your point, I agree that it's, you know, this idea of the, that it has a lot to do with its enforceability. So like saying you know, you cannot harass your tenant. I mean, that in some ways, there's a line about that in state law, but what this is really being very specific about all of the ways that landlords will make tenants feel uncomfortable in their home. And it is about mandatory attorney's fees, so that it just increases the likelihood that tenants are able to find attorneys, that it's only if tenants prevail. And then the other is making each action, you know, not making it $150, but, you know, like LA saying 2,000. I think that I want to say that Oakland's is only 1,000, but, you know, that each time they do it, that there's a serious consequence. And then obviously triple damages makes a, you know, is another reason, because you're trying to make the consequences not be worth it. We're seeing more and more that insurance companies are carving out harassment, you know, but I think that it is still makes a big difference. The other piece is to be specific. You know, I think that even from an organizing perspective and a tenant empowerment perspective, that landlords, as they become creative and decide to come up with a new and worse way to harass, that, you know, tenants can organize, come back to city council and say, okay, this is the new way they're doing it. You need to put it into that list. And I think that that can really make, so that's another reason, is that it's not just this vague one paragraph, but all of these different specific pieces, you know, going into the unit too many times. You know, that was a big thing in a case that we filed in Oakland using the ordinance, where the landlord was giving notice for almost a weekly going into people's unit. The use of cameras, taking pictures for no reason other than just to stress out the tenant. Going on to, someone had asked about buyout ordinances. So a buyout ordinance is came out of, and, you know, the one that I was I mean, these existed before LA, I mean, excuse me, that Oakland passed it, but the reason is it really makes a difference, prevents tenants from sort of being tricked in to agreeing to a buyout when they never had to be evicted from in the beginning. kind of a memorable example for me was you had a triplex, and this was back in the day where in Oakland, if a landlord moved into up to a triplex, they all lost all their protections. And so what they would do is they would convince one of the tenants to move out, saying the landlord was going to move in and that they were going to give relocation to whoever moved out first, because everybody after the first eviction would no longer have just cause and would no longer get relocation, even though they never intended to move in the first place. They just wanted people to move out. And so generally buyout ordinances will say, you have that anytime a tenant signs a move out agreement, that it's not that they have to basically usually file paperwork with this local city and saying, hey, we're going to be asking our tenants if they want to volunteer to move out. And then some cities have actual materials that they have pre-created that landlords are required to give tenants that say you don't have to move out. These are the only reasons. And you can get legal assistance from here and here and here. And most importantly, we'll tell them how much the relocation amounts are. Now, in the event, and then it gives tenants time, even though if they sign it, to still, they have usually some period of time where they can say, you know what, never mind, I don't want to do this anymore. And then the huge consequence is that if you don't participate, you don't follow the rules of the buyout ordinance, then essentially the ordinance in itself doesn't count. I mean, the agreement is invalid and the tenants don't have to move out. And they also, it has, as always, attorney's fees clause to enforce it. And so that can be an important component. The other thing I would add that I think is kind of an up and coming issue around, in terms of a policy, are these tenant habitability plans. And this is something that Los Angeles has, that Berkeley is passing, that Richmond is working on. These are like basically requirements that when landlords are going to do major repairs in properties that are occupied, that they have to basically have a plan to ensure that, and to mitigate essentially the impact on tenants during that construction. And as we see, this upzoning, which really what that means is fill in construction where you're going to have ADUs being put in. All of those things are, really having these processes that protect tenants will make a difference. Another theme that we're seeing that is also related to that is where landlords are taking out permits to reconfigure apartments that tenants are presently living in. And so tenants will move out for the weekend because the landlord claims they're doing something, and then they come back and they have turned their 2-bedroom into a 4-bedroom and have almost no living room anymore. Another question is talking about proactive inspection programs. Yes, proactive. And the question is, what do we think of these, and have you seen any good models? I think every city must have a proactive inspection program. I think that the best models are, we drafted one for the county of Alameda that I think is great, that wasn't used. But, I think the model that Los Angeles has, I still think is really strong. I think that one thing we've noticed is that it's been very difficult for code, and just for folks who maybe aren't as familiar, when I say proactive inspection, what we're talking about is that on a regular basis, every unit is inspected. So it's not kind of so it's proactive versus complaint based. And I think that I think it's actually required. If you've heard me speak before, that I always talk about that every community has, there are 5 policies every community needs to have, rent control, just cause, anti-harassment, enforcement, and proactive code enforcement. And especially if you if you think about when they're trying to claim that rent control is not a good policy and they claim that landlords are not incentivized to make repairs, you know, I think all of us will say, well, they're required to. It's not really a choice. So whether you have rent control or not, and ironically, in the communities with less tenant protections are where the worst conditions are. But I think proactive is important components, that it's all units. We've seen problems where it's either they only look at 10% of them, that they say, you know, a lot of people can do self-inspection. Those are not a good idea. And I think that, but one thing that I think can be done is a tiered approach. So, you know, you kind of do an inspection of all the different units. And then once you've gone through one time, the ones that kind of went through with no problems, then maybe you wait 5 years on those, and then the rest, or, you know, 4 years, and then the rest you do again in 2 years. So kind of, because I think it's definitely been consistent that it's been hard in communities where they pass these ordinances, you know, how to manage actually getting into each one. Code enforcement officers are hard, like it's been hard to hire. There are not a lot of folks who are trained to be able to be inspectors. You have to have a lot of construction background. And then, yeah, so that's been one of the struggles. But what's key is every unit, and on a regular basis. And then I think that there has to be enforcement at the end of it. You know, Los Angeles has what they call their REAP program, which I think is really, the idea of it is really, really good. It's where landlords basically, if they're not making the repairs, they have to essentially pay the rent into the city, and then the city has the choice to repair them. I think one of the things is that what other cities have done is that tenants can then file petitions. So that's kind of like I call the Northern California strategy, is that if landlords aren't making repairs, tenants can then file petitions with their rent boards. The dilemma is what happens to the units that aren't under rent control. And that's where having kind of a different system can be more useful. So then the other question is, which is a common question around, so what happens when you have these proactive code enforcement programs, and what happens with tenants in illegal units or substandard units protected? So I'm going to talk about the substandard units first, because that's the easy answer. So and I think I was talking about the tenant habitability plans. That's the solution. That's how you protect tenants. So you protect tenants. First off, you cannot be evicted because landlords have to make repairs, that they're temporary. If it's so bad that they need to move temporarily, that they have the right to come back, and that landlords clearly have to pay the costs to keep a tenant housed while they're improving their unit, and that the tenants always have the right to come back. That landlords can't put the costs of having to fix those units onto the tenants, so that hopefully incentivizes landlords that if they are maintaining the property, right, then they don't get rent reductions, they don't, and you can qualify for capital improvements if you're maintaining the property. But again, those tenant habitability plans, right, where the landlords, when they go to get permits to make those repairs, or in response to code enforcement, doing these, these tenant habitability plans. So that's really, so how you protect tenants when you have code enforcement programs is that you ensure the tenants cannot be evicted because they're doing major repairs. The landlords are responsible for paying for the cost of having to temporarily vacate, and always have that right to return. And in terms of when tenants are in illegal units, I think that the key is to distinguish between an illegal unit and an unsafe unit. And I think that if it's in a unit that's not there with permits, then the landlord is cited for not having permits, and then they need to get the permits. If they are it's just completely unsafe. We had an example where a landlord had basically created a unit into, like, you couldn't even stand up, you couldn't even sit up, you basically could go in and sleep, and the landlord had, turned that into a rental unit. I mean, it just didn't, it was completely unsafe. It had no windows. It was just like a cubby hole, and they have to get full relocation. And that's what happens. But I think that one thing I would say is that my experience has been in cities that have implemented these issues, that landlords, if it's safe, landlords cannot evict without paying relocation, but that they focus on getting a permit and figuring out how to get the permit. And it hasn't led to mass displacement because you have such, policies like a habitability plan and strong tenant protections, like you can't evict for, substantial rehab. I think the real struggle is going to be in communities where they can evict when they can do rent evictions. So that's why local units are important, or local protections are important. All right, well, we are almost at time. I think we've covered the questions. Thank you for my colleagues for asking some creative questions to make sure we're all continuing to have this conversation. Yeah, thanks for joining us, and glad you're all out there, because it's going to be a hard